apparently there's been a development with the Nick Rekieta case. I don't want to go into graphic detail or anything else, but Kurt, Nate, I think you guys both covered it. I don't know if you have, Dave. What's going on with Nick Rekieta, his case, and what's the status?
Yeah, long story short, okay, Nick Rekieta was arrested and charged with possession of cocaine. Most recently, he filed an omnibus to have his case dismissed on the basis that the warrant was invalid.
What's an omnibus?
It's a all-purpose motion.
Okay.
So it's a motion for all purposes. So it's multiple different things. Anyway, so he filed a motion to dismiss, essentially, on the basis that the cop lied and asked for what's called a Frank's hearing to determine that. And the judge determined
did the cop lie about?
That he didn't actually, according to Nick, that the cop didn't actually view the original video because he viewed it somewhere else and it had a watermark on it, and that makes it different.
Well, there's also 4 seconds difference too in the length of the video.
No, there wasn't. It wasn't. It was exactly the same.
Was it?
Yeah.
Okay.
Yeah, it was exactly the same.
Well, sometimes when they wrote it, they didn't quote the full number because they just said 4 hours and 4 minutes instead of the additional. So depending on how they wrote it, but it was the same video. It doesn't matter. So, and that's exactly what the judge says. It was the same video. It didn't matter. And then the judge also said that he failed to preserve the issue of the sufficiency of the probable cause, and that issue is gone. So there's no more basis to oppose the warrant. So that's gone, which means that we're going to trial. And it also means he's going to get convicted because, as I've said before, this is a simple possession case. It's a 2-witness case. Witness number 1 is the cop. Hey, cop, did you go there? I surely did. What'd you find? I found some drugs. Did you wear a body cam? Yep, I did. Let's roll that footage. Is this you with your hand with the drugs in your hand? Surely is. Thanks, cop. No further questions. Second witness, the lab tech. Hey, lab tech, did you test the stuff? I sure did. What was it? Drugs. Great. No further questions, right? And anything beyond that is bonus. And so since they have no basis to, like, we're going to trial. So it's the end of the game. Game over, man. Game over.
Yeah, he needs to take a plea. Like I said from the beginning, though I will say this. I don't fault him for filing a motion. Everyone wants to tease him about filing a motion or the motion was dumb and the judge was mocking him for filing such a thing. As a criminal defense attorney, what you do is you take the case and you start poking as many holes as you can into it and see where those holes lead. And if they don't lead anywhere, then you start talking plea. But you at least got to try to poke some holes so that you can get your client the best deal possible.
Yeah, because if you don't make the argument, it's automatically going to be a no, right? So you have to at least make, as long as it's not frivolous. And I don't think it was borderline. It was borderline. We were getting close to being frivolous, but it wasn't frivolous. But I think
the video thing was borderline frivolous. That I thought was really ridiculous.
Yes, because he was saying the only difference with the video was the watermark. Yeah. So just so everybody understands, with a Frank's hearing, you have to show that if the cop lied, it was material. It would have changed the outcome of the warrant. The judge would have said, "I'm not going to issue that search warrant because this was so important to whether the warrant was issue or not." So Nick's argument essentially was that his original video and the other video that the cop watched were different, and the only difference was that there was a watermark on the video the cop used, and that watermark materially changed the video, but it didn't. It was how YouTube puts a little watermark on the bottom right hand side of the video. That's what it is. Matter of fact, here is Rekieta. And now somebody put this together, which I think is hilarious. They put together literally a video of Nick arguing against Nick, because there was a video Nick did about a Frank's hearing, about how do you do a Frank's hearing, and then it was a video of Nick actually arguing about his issue with the Frank's hearing. So someone put it together, and it essentially explains the whole Frank's hearing issue. So here it is. I'll play it. But it shows you, and it also shows you one other thing too. Why it's dangerous for you to play lawyer in your own case, because sometimes you lose that objectivity of understanding, what's going on. But this is Rekieta versus Rekieta, Frank's hearing.
What is the difference between the videos? Well, one says backwards internet on it. There's the difference. That's the only difference that matters, because it's different.
Objection!
So Frank's challenge is just a challenge to any of those statements. It says they're a lie and says that that lie is material. Now, if they make some misrepresentation that has nothing to do with issuing the search warrant, then oh well. Hold it! That's not the question. The question is, why didn't the cop just not lie? So if you're stuck in the analysis of arguing over the quality of evidence, you're way in the wrong part of the trial. Objection! The idea is that alone, like they lied once, is not enough to overturn a warrant. They have to lie in material ways that are to the issuance of the warrant. And that's what Frank's challenge is for. Hold it! Well, one says backwards internet on it. There's the difference. Objection! But did it, if they change that, if they get rid of that line, does the search warrant still issue? If so, objection! You're not in the right spot. And I'm sorry that practicing lawyers have misled you into the wrong analysis by not being competent at what they talk about. But they have. They have misled you. They have let you down. They have done so to extract money from you.
Is that the Ace Attorney game sound effects?
Yeah, but Nick was right. It had to be material, and it wasn't material.
Yeah.
So it said it just wasn't material. Well, the Nick who was saying that it had to be material was right.
Which Nick won?
Yeah, exactly. he can't appeal as a matter of rights because it's not interlocutory automatically. He can ask for permission, but he won't get it because there's no novel issues here, and the Court of Appeals isn't going to take it up at this time. So the only way to appeal it is to get convicted and then appeal it then, and you'll still lose because the judge was right.
Even though we focused on a Frank's issue, there was also a firearms issue. So when the cops did the search, they found the cocaine, and then they found some firearms. But the thing that made the firearms illegal was the cocaine. So they found the cocaine, field tested it, tested positive for cocaine. So then they would seize the firearms under the probable cause that there was illegal drugs, because you can't have illegal drugs and firearms.
So the drugs made the firearms illegal. So if they walked in, there was no drugs, and there was a gun laying on the table, that would be irrelevant. It's just a gun.
Correct. They wouldn't be able to see.
My original prediction was this is going to result in a plea where he does probation only, no jail time. The firearm charge is going to get dismissed, but he's going to have to surrender the firearms, and then he won't have the restriction going forward. That's my prediction. That was my original prediction, and that's what I think is still on the table.
Well, he tried to get the firearms tossed, but the judge, obviously, it came just down to the plain view exception. Exactly what it was like. Well, they were searching for drugs. When you're searching for drugs, you can essentially search anywhere, and they found the guns, and then so so the judge said it was a plain view exception. So the guns do come in, so the gun charge is still live, and then the child endangerment charge is obviously still good because you got drugs, you got guns, you got children. It just wraps it all up. So you get the child endangerment charge. So
can he plea out of a felony? Because that would mean he couldn't vote. He would lose his gun.
He can plea out of the felony and have those dismissed. The child endangerment's probably not going to go away, but it's going to get wrapped up into the same probationary period. And they have the other child protective proceedings and all that. That'll probably be used as sort of an advisory guide with regard to the probation on the criminal thing.
And let's not forget, though, too, they also found other substances there that they seemingly haven't charged them for, like the ketamine, for instance. So, they still have that ace up their sleeve if they really want to.
Is ketamine illegal or not?
Yeah,
I don't know.
So no Bruin challenge?
No Bruin challenge.
Surely that one's pending somewhere in some circuit.
What's a Bruin challenge?
So the Bruin is the U.S. Supreme Court case that came down a couple years ago that threw the whole Second Amendment jurisprudence into chaos because they basically said that any restriction on possessing a firearm has to be well grounded in established tradition and history and stuff like that. Basically, an originalist approach to firearm restriction. And so since then, there have been all kinds of challenges raised to various firearm restrictions, waiting periods, age limits, felons in possession, having a no contact order, like any basis for restricting someone's gun ownership has come under challenge. So making a gun illegal because drugs are present, just, it's an obvious Bruin challenge. I just don't know if he's raising it.
Well, it's a Hunter Biden situation too. It doesn't share the same.
Yeah, Hunter Biden. Yeah. It's wild because, to see Hunter Biden, who's a Democrat, use the NRA, like that's the NRA's thing. Like, yes, you should, because what caught Hunter Biden is that and on the form he filled out, it asked, were you using drugs? And he puts no. And the NRA has said from jump that should be illegal. You should, even if you say yes or no, that should be irrelevant. They can't on a question remove your right to own a firearm. So that's essentially what Hunter Biden said, which I do think. I'm again, people will call me a gun nut. I'm more on the NRA side with that because I
came too.
That's right, but I think if you have actually cocaine in your home, then I think you're talking about maybe something.
Yeah, but a question on that, Nate, and I don't want to go too far, but it's like, okay, so if you have cocaine in the house, boom, it's automatically a felony, but you could be drunk out of your everlasting mind, cross-eyed, peeing yourself, and carrying the gun around your house, no worries, no problem. It does seem a little odd.
I think the distinction that maybe you're missing here is that you are in possession of a firearm in the commission of a crime,
of a felony,
right? So you're committing a crime or a felony by being in possession of these illegal drugs. That's the issue. So, or any crime that you're committing, if you're in possession of a firearm while you're committing a crime, that's sort of the
I know, but I feel like it's stretching a little bit far because it's obvious that if you're robbing a bank and you have a gun, that very much they compound each other. But a possession charge where you have a gun present at your house, I don't know. I understand that's what they're saying. It's
not aiding the commission of the crime in any way. It's
right.
They're unrelated, that would be a whole different thing.
Exactly.
If the gun were aiding the commission of the crime, we'd be talking about first degree because that would elevate it. So that'd be a whole nother thing. But I'll tell you what, if it winds up being Hunter Biden who goes to the U.S. Supreme Court and gets us further gun rights, hey man, I'm here for it.